my attitude towards this is here in the United States that the only way to decolonize is to get rid of the apparatus of federal Indian law and recognize native nations as fully sovereign native nations within the nation. It was originally John Marshall in the Supreme Court in 1823 through 1833 in three formative cases that recognized that the United States government under Andrew Jackson at that point would not tolerate nations within the nation. And even though treaties were signed, and this is what the Cherokees came to the court to say in Cherokee Nation versus Georgia, 1831, even though treaties were signed with native nations, making them nations, by the way, in that act of signing treaties with them, making them foreign nations, and the Cherokees came to the court to assert that. They wanted protection against Georgia, which was overrunning their land, abrogating their laws, et cetera, Jackson would not send troops down to fight Georgia. And Marshall recognized that declaring them fully sovereign nations would lead probably before it ever happened to a civil war of sorts. I mean, you can say in 1831, the South was already mobilizing against the federal government in various ways. And then 30 years later, you do have the Civil War. This would have, I think, promoted if the Marshall Court had recognized Indian nations as sovereign foreign nations, which they were according to treaty, then you would have had the Civil War starting in 1831, 1832.